Is someone from our own bar. It's a special moment for whole SCBA, sir. With this, may I now request Honorable Mr. Justice Yuyu Lalit, Chief Justice of India, to kindly give his address.
All my brother and sister judges of the Supreme Court, Mr. K.K. Venugopal, Learned Attorney General for India, Mr. Vikas Singh, President, Supreme Court Bar Association, Mr. Pradeep Rai, Vice President, Supreme Court Bar Association, Secretary and Office Bearers of the Supreme Court Bar Association, Learned Solicitor General of India, Mr. Tushar Mehta, all the officials, office bearers of Supreme Court Advocates on Record Association, my former colleagues at the bar, whether senior advocates, juniors, all of you. I see so many familiar faces, some who were my chamber juniors, some who worked with me, some who argued against me, who walked with me every time. So it's a gathering which is like, makes one nostalgic. There are some people that I shared table with at lunchtime, or maybe for the purposes of coffee in the canteen. So it's to all of you. Where do I begin? I came here way back in '85, but before that my first brush with Supreme Court was in 1979-80 when In Re Special Courts Act was being argued in this court. That time I was a student, and because that was my first case which I followed. I sat there all through, headed by Justice Chandrachud, Y.V. Chandrachud, the then Chief Justice, Justice Bhagwati, Justice Krishna Iyer, such stalwarts. So that was a great experience, great learning experience. Then again, I had the great fortune, though I was practicing in Mumbai from '83 onwards. I came here during vacation to mention a matter. In those days, the mentioning used to be before the then Chief Justice. So Chief Justice Chandrachud was the judge. So my first appearance in this court was again before Justice Chandrachud. And that's when it started. I have been through almost every role that an advocate can be in Supreme Court. I came here purely as a student first, then as an outstation counsel, then as a junior who was unattached to anyone, then joined Advocates on Record Office, then joined a senior's office, then practiced like non-advocate on record, non-senior category, then became an advocate on record, then suspended my practice as advocate on record for a while in the hope that I may get designated, and finally designated. So therefore I have been through everything which possibly any advocate in Supreme Court could have gone through or can go through, except one. I was never a law officer. And at times people say that, very well, you have a distinct way of arguing. I must tell you the secret. The man behind that is none other than Mr. K.K. Venugopal. You should see Mr. Venugopal argue a matter, the way he places the matter, absolutely calm. There are no sort of emotions at any juncture. Just places the matter, facts, law, with same amount of ease, comfort, putting the court in complete sort of comfortable zone. With the permission of Mr. Venugopal, if I may share one incident, when I joined Parekh and Company, there was a huge shipping matter, and we had briefed a senior counsel. So in the conference, on some point, the senior was not happy with the preparation and the kind of pleadings which were placed on record. So he just flared up, started blasting all of us, including the clients, for the way they had conducted themselves. And he went to the extent of saying that the proper place for you is actually in a jail. When the conference was over, we were told that, sir, we want somebody else. Very well, with a lot of reluctance, lot of sort of, trying to persuade the clients not to indulge in that, but they were insisting. So we went to Mr. K.K. Venugopal. All of it, which had enraged that earlier counsel, was narrated to Mr. Venugopal. And the expression was, and I don't forget that because that is something which has ingrained in my mind, all that Mr. Venugopal said was, "Ayayyo." That's the cool temperament which I saw, and he has always been a role model. Very well, lot many things have been said about everything, including listing and other things. Let me clarify. It is true that we have taken this new style of, new way of listing. There are naturally bound to be some teething problems. Whatever has been reported is not the correct state of affairs. We all judges are completely on same page. In fact, as a matter of fact, what Mr. Venugopal told us, that till yesterday, that is till about, say, 29th we began, till yesterday, we could dispose of more than 5,000 matters, 5,200 to be precise, as against filing, which was just about 1135. So fresh filing is 1135, the disposal is 5,200. So that is all possible because of the efforts put in by my brother and sister judges and all of you, the members of the bar. It is true that as a result of this changeover, there have been certain occasions, certain instances where perhaps the matters got listed at the 11th hour with the shortest possible notice. That created tremendous amount of workload, additional workload for the judges, for the advocates. And I am really indebted to all my brothers, sister judges for discharging everything with a smiling face. And that's the reason why we have been able to dispose of something like 5,200 matters as against 1135 filing, which means that we have been able to reduce the arrears by at least about, say, 4,000 number, which is a good beginning. Of course, these are all matters which are matters of moment. Why? Because many matters were pending. They had become more or less infructuous, so therefore they had to be disposed of, so we got them listed, and the results are before you. The second part, and I must respond to what Pradeep Rai says. I don't know where he gets all these information from. Let me share one thing. It had always been my dream that, one day, if I can be judge of this court. Nothing like that. My wife was always aware of that. She knew everything that was at the back of mind. So there was no necessity, no need to consult her when the actual call came. And that's the reason why I said in one of the speeches that when Justice Lodha offered me, I did not even consult my wife. It was in that background. It is not as if no husband can ever do such thing, without consulting the wife. Now we come to the third part, which is the demands. The demands are ever growing. The demands are naturally because that's the vibrant way in which the bar, it's a dynamic concept every time. Whatever library that I saw way back in 70s, 80s, that library can't be sufficient for today's needs, today's demands. Number has increased. So therefore, it is true that these concepts will certainly require more and more space. I can't promise anything. The only promise I can give is, very well, I'll appoint committees. So let the committees go into that. Committees will decide, and then thereafter the decisions will be taken. So all in all, it's a great privilege to be here standing before you. I consider myself to be lucky that I was member of this bar association. This profession, this bar association has taught me everything. The conduct of matters, the way seniors used to argue, I would run from court to court, just watch the seniors, how they functioned, how they argued. It has always been a great experience, great learning experience. And that has been given to me on a platter by the Supreme Court Bar Association and the institution which is Supreme Court. It's a privilege to be a lawyer. This legal profession has given me everything. Whatever I am today is only because of this legal profession. I can't consider myself to be anything other than this profession and what it means to me. So being a member was a matter of privilege to me, and it's the same privilege with which I stand here today before you. Maybe in 2 months' time, when I demit office, that will be the final icing on the cake. Thank you so much.